Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 57, Who's Your Womma? Hi, this is Denise Howell, and you've joined us for TWiL, This Week in Law. This is episode 57. We're recording on April 23rd, 2010. And I'm here today with Ernie Svensson, live from Rained Out Jazz Fest in New Orleans. Good to have you back on the show, Ernie.
It's good to be back. It's not rained out yet, so don't everybody who's going to Jazz Fest keep going to tune in live.
Sorry, just damp Jazz Fest. Yeah. And Evan Brown in Chicago. Evan, great to have you back on the show.
Hi, Denise. Great to be back. Thanks for the invitation.
And our newcomer, the googly lawyer himself, Kevin Thompson in Nashville. Kevin, great to have you join us.
Hey, it's a pleasure. It's an honor. I appreciate the invitation, Denise.
Sure, my pleasure. Why don't you tell us about your googly lawyer moniker and how that came to be, thanks to Jeff Jarvis, another regular here on the TWiT network and author of Buzz Machine.
Yeah, I read the book and I thought it was just a brilliant book. And
his
I guess
book
it came
being
out of
What Would Google Do?
What Would Google Do? Right. It was very insightful, and I'm just intrigued by the tech space, and I thought he really targeted what Google did right for their success. He had a chapter in there about googly attorneys, and he basically said there's no hope. Lawyers are somewhat insulated from the realities of the marketplace, and these rules don't apply to lawyers. And so I sort of just sent him a message on Twitter and said, hey, I sort of disagree with you, and I think that attorneys can leverage technology to decrease costs and offer better services. And he sent me a response back, and I think it was an invitation to sort of explain my thinking. And so I just did a short Vidler video, sent it to him, and he posted it on his website, Buzz Machine. And the thing got like 800 views in one day. Which was pretty cool. And yeah, I just outlined my thoughts about how how attorneys can leverage technology to be more efficient, to drop their costs, to really target small niche markets. I've got a background at a law firm in Knoxville. We did insurance defense work, right? And you're a commodity. When you compete with 1,000 attorneys in a finite marketplace and you do just basic work, you can't charge too much for your time. And now with technology, assuming you operate on a federal level, you're not limited to a particular state. With technology, you can focus on really small niche practices. You can be the expert divorce attorney for women, or in my case, an MLM attorney, a multi-level marketing attorney. Very small niche, make a good living. So it's exciting times we're in.
Yeah, I think Jeff's point in his book was that it's hard for both lawyers and PR people to be transparent enough to be what he considered have a Googleified business kind of approach, because their motives are always subject to question, because they always have the agenda of a client's needs and interests behind them. And, to some extent, there's no getting around that point. But I think your response was that, yes, but you can still be transparent in the things that you can be. You can't disclose client confidences. You can disclose who you represent and what their interests may be.
Good point. You can be. You can't obviously disclose client confidences, but you can be an advocate for a position. You can be a leader in a particular field advocating change. And I'm a big fan of Seth Godin. He always says you have to ride the edge. You have to identify what the edge is, and you have to ride it. Because if you're just like everybody else, you're just not special. You're not going to get much attention. And so what I like to do is I like to find the sore spots in my particular industry, and get a conversation started, kind of spark up a little controversy. And it's not exactly what Jeff Jarvis is talking about, but in my opinion, it's googly. You're leveraging the platforms to communicate, to create a broad audience for what you're saying. So I don't know. I like
right,
it.
and have a dialogue about things that otherwise would just get talked about in court papers and demand letters.
You got it.
So it's great to have you on the show, and I do want to get into a little bit more about your practice in a bit, but I wanted to start out with some current events. We have had a busy week in law, and law and technology in particular, as we like to discuss on this show. And for folks who want to see the rather lengthy list of things I hope to cover in today's show, you can check out delicious.com/thisweekinlaw/57 and see what we're going to run down. Now, one thing that happened this week is the blog Gizmodo got its hands on a 4th generation iPhone through the purchase of that device from an engineer who happened to be out at a bar and left the thing there. I think that's what happened. He lost it. The bar or somebody in the bar found it. Gizmodo bought it and proceeded to publicize it, take it apart, etc. And the end of the saga was Apple's official folks getting in touch with Gizmodo and saying, yes, we'd like our device back, basically confirming that it was what Gizmodo said it was. So there's been some speculation about the legalities of practicing journalism in that way. And we have one link in the show notes by Jeff Bercovici from Daily Finance about why Apple should sue Gawker over that lost iPhone and what it did there. Ernie, have you taken a look at this, and what do you think versus encouraging thievery or simply practicing aggressive journalism?
Oh man, I have so many thoughts about this. My first question, well, first of course a disclaimer. We don't know all the facts, I don't think. I'm not a California attorney, so I don't know what the law in California is exactly, although I've read a lot of posts. John Gruber, his post covered the criminal law aspect. I've heard people weigh in on trade secret law. And I'm familiar with those general provisions. Louisiana has something similar, but I can't say that I'm going to be accurate about California law. But the main thing is I think we don't really know all the facts yet. And so what I find intriguing about this whole thing is that, Apple, which has this propensity to play things very close to the vest and not talk about things, versus Gizmodo, who's in the business of leaking things as quickly as it can. Actually, Apple, from the standpoint of, from a lawyer who says, gee, maybe you shouldn't talk so much before you get yourself into trouble, because once you say something, you're committed to that position. So usually a lot of clients, and people that you deal with aren't fully aware of how easy it is to put yourself into a box by what you say. So actually, Apple's in a better position because we really don't know what Apple's position is. We don't know what the engineer who supposedly lost the phone has to say about it. We assume the phone was lost and not stolen because I think, as far as I know, and correct me, anybody, if I'm missing something, but so far, all the information has come from Gizmodo, and then Gizmodo is relying on the person they bought the phone from to tell them how the phone came into their possession in the first place. So we assume that the phone was lost. But, and this goes to my point of, be careful what you say. Gizmodo, when it posted the link that says a letter, Apple wants its secret phone back, and they posted the letter from Bruce Sewell saying, yes, please return it to Apple. They talked about their response back to Apple and said, happy to have you pick it up. Was burning a hole in our pockets. Just so you know, we didn't know this was stolen. Now they go on to explain, what they meant by stolen because they had posted this earlier and maybe thought that wasn't such a great word. So then they try to qualify the word stolen. John Gruber's post, I believe, is the one that has the original verbiage without their qualification. But later on in the story, they say, our legal team told us the law in California says if it's lost, the owner has 3 years to reclaim it. and so forth. But then they go on to say, well, the person who found it, in other words, Gizmodo is saying the person who they bought it from, the person who found it, had the duty to report it. So they're saying, essentially, not us, that guy had the duty. Then they say, which actually the guys who found it tried to do, but were pretty much ignored by Apple. So, I mean, if it was stolen, that doesn't really jive with the later part of the paragraph. But in any event, whatever the facts are, you have Gizmodo just blabbering on about what happened, because that's what they do. And I guess that also helps them keep the story alive and get more, page hits and click-throughs and so forth. But Apple is being quiet, not saying anything. So the big question, for me looming is, what is Apple going to do? If they do have a claim, and I guess we can discuss that in a second. I'll turn that over to somebody else. But if they do have some sort of claim, or if Apple can push the police department in that jurisdiction to investigate, are they going to do that? And I would think if they can, they would, because of the poor PR way that Gizmodo has handled this. And that's another whole topic that we can get into.
Do you really think it's been poor PR for them? I mean,
I don't mean poor PR in the sense of it coming back. I mean poorly executed, because it may not be worth what they get out of it. I mean, if you wind up getting yourself in a really difficult legal jam, then it might not have been worth for them to do it the way that they did it. Like, if they found a phone and they said, okay, fine, and we can talk, but this has been discussed all over the place, so we can discuss it as well here. But there is the question of how did they handle it, and I don't think they handled it the best way that they could, because they could have gotten the PR they needed without triggering so much of the negative effect that, in my opinion, they're going to get. I really will be surprised if there's not some sort of legal action, whether on the part of Apple directly, or whether on the part of maybe some district attorney, if Apple presses them. But we don't know. We don't know what exactly happened. I mean, we're assuming that the thing was found in a bar and that it wasn't stolen. But even Gizmodo uses the word stolen, so maybe the phone was stolen in the first place.
You see, maybe I'm just way too cynical about all this stuff, but I wouldn't put it past Apple to have just staged this whole thing to shroud its new thing in mystery. And knowing that it kind of reminds me of what Trent Reznor did a few years ago, when he would hide USB drives in the bathrooms at concerts, and people would find them and take them home and get clues to this much larger game, so to speak. It was that marketing effort. I would almost bet the farm that there's not going to be any prosecution, no lawsuits. This is going to die down in about a week here, because it wouldn't put. I just wouldn't find it surprising to think that this has been some kind of deliberate effort. Maybe not from the top down, but something to have this mysterious little device show up, lost in a bar somewhere, conveniently found by Gizmodo. It's perfect. This is a wonderful little thing that's gotten people talking. It's furthered the mystery behind yet to launch Apple products. It's generated buzz. It's been good for Gizmodo, really, in the end, if you think about it. And here we are, laboring over it still ad nauseum. So maybe I'm cynical.
Yeah, thanks to Frank Painter for pointing me toward the Urban Dictionary April 21st, 2010 word of the day, which was proto-hype, the process of leaking a prototype device to generate buzz about a product you don't quite yet have ready for market to a friendly tech website who will promote the gizmo well before it's ready to go.
Right. No coincidence at all.
Complete with lovely photo gallery of the device itself. Drool-worthy photos. So,
Gizmodo is a good asset for Apple. They talk up the Apple brand all the time. So if Apple goes after those guys, they're going to be perceived as a bully, and they're going to be blowing out one of their key assets, which is a popular website that really talks up the Apple brand. And there's always an Apple article every single day on Gizmodo. And like what Evan said, this is sort of how Apple operates usually. Now, in this case, it seems like it was out of their control and they didn't orchestrate this. Maybe not. But this is what they do. They leak information. There's a buzz. There's a frenzy. It creates conversation. So, slap them around a little bit, but I don't think Apple should pursue legal action. I think that'd be bad for business. Technically, they could, but it's a bad PR strategy.
Well, they certainly have a history in California of doing just that. In fact, one of my favorite posts about this whole topic this week came from Jason O'Grady over at ZDNet. It's called "How Will Apple Punish Gizmodo?" And it's very tongue-in-cheek. And the first thing that he says was, and Jason O'Grady, by the way, was the guy who leaked the photos on his then Apple rumor/coverage site of the asteroid device. And this was way back in 2004. So the first thing he says is Apple Legal will subpoena Gizmodo's ISP and request all of its email for 3 years so that it can find the leak. No, wait, Apple did that to me, which they did. We had this.
That was funny.
California, that resulted in some interesting statements from the California Supreme Court about the ability to access that kind of information. So who knows what may come next, but it certainly has gone down that road before. Kevin, you were going to say?
No, I wasn't going to add to that, what you just said.
I think it was actually, I was going to respond that
yes,
all of that assumes that Apple would have planted this. And I think that people that know what Apple's interior operations are like, John Gruber, Merlin Mann, there's other people that have talked about this. They are of the firm opinion that there's no way that Apple would have orchestrated something like this. I also agree. I don't think this is not their motive. They control things. They're not going to leak this out and then say, well, let's let it kind of percolate out there in the world. They would never do that. That's not Apple's MO. But let's assume that it's not. Let's assume Apple never really intended for this to get out, that it was truly a mistake, the engineer lost it. Then what? And that's where I think Apple probably will do something, because they did go after, they have gone after people. They take this stuff seriously, and they don't. And if they didn't leak it, which I can't believe that they would have done that, but maybe that's possible. If they don't go after them, then maybe it's because they leaked it. But I don't think they did. And if they didn't,
the chat room agrees with you. People are saying no
can
way.
Can they sit back and just say, well, we lost a phone, no big deal? They're going to have lawyers poring over every statement that Gizmodo made, the rationale. They're going to have access to their own engineer to tell them, well, what happened? And maybe his story is, I don't know, I was sitting there and all of a sudden I turned around and the phone was gone. And I thought maybe I lost it, but then I realized after a while that it was probably stolen. So maybe they always knew it was stolen, but they're not going to say anything because Apple doesn't talk. But in the world of litigation, he who talks less and talks less, cavalierly, usually is better off. And in this case, Apple has an edge. That's the way I see it.
Right. Well, we will just have to wait for that shoe to drop. What we know for now is that the device is going back to Apple, and we'll have to see if Dr. Media finds itself on the wrong end of a lawsuit. But if they do, we'll be sure and talk about it. One other thing that we've talked about before that we're going to talk about again this week is the Marion School video camera case that is pending back in New Jersey, where a school district was secretly operating the security tracking technology on its school-issued laptops. Apparently, a motion has been filed in that case that gives more information about what was going on and what sort of imagery and the volume of the imagery that were captured in that case. And it's pretty outrageous. Over 56,000 images, apparently, and some of them just of students sleeping. Anyone want to take a shot at what's going to happen in this case and whether it's going to be the end of schools being able to monitor students whatsoever with their technology? Kevin, any thoughts on this?
Yeah, I think it's a clear violation of Fourth Amendment protections in that if you give somebody a computer, I think there's an expectation of privacy, but now we're flirting into the Supreme Court decision that came out last week where a police officer was given a BlackBerry, right, and he was sending text messages, and the employer got the text messages, and that the issue was, does an employer have the right to get that data if they provide the phone and if it's an employee? And the Supreme Court said yes.
Just to clarify, the Supreme Court hasn't ruled. They've only had argument on that case.
Oh, sorry about that.
Yes,
okay.
The argument was last Monday, and so we're going to talk about the argument in the case, but we still don't know the outcome there yet.
It's sort of a parallel issue. I think in that case, if it was clear, it probably wouldn't have got to the Supreme Court. But in my opinion, if it's an employer...
It was the Ninth Circuit. That's why it got to the Supreme Court.
Okay, right. All the cutting-edge law comes out of the Ninth Circuit. It just seems like if you provide somebody with a device, there's not an expectation of privacy. But in this case, the facts are just different. This is creepy, right? If you're using a phone for business purposes, I think that's a different ballgame, and I think the Supreme Court decision is going to rule in favor of the employers that provide the device. Here, a school giving computers to kids, it just sounds creepy. I don't see a court siding in favor of the school. I think there's an expectation of privacy, and you're going to be hard pressed to find a judge that really tries to weave some logic to give schools this kind of access to a kid's personal life.
Yeah, I would tend to agree with you. Evan, any thoughts on the new information that came out in the motion in that case?
It's interesting. The report that we read here says that it came from one of the school district's lawyers, and I think it's important to not over dramatize this. One of the facts here that has come out here is that all of the images that were taken were from machines that were reported stolen. So that tends to detract a little bit from any argument that this was anything but a targeted endeavor. With that said, it's still pretty outrageous. It's creepy and all that stuff. This is a case that we will probably never get a substantive ruling from a judge on, so I don't think we're going to learn anything on the law here. It's going to settle for lots and lots of money, and it's not going to have any kind of real effect on whether school districts can issue machines to students that have the capability of conducting surveillance on them. What it will do is indeed raise awareness of this, and hopefully school districts will be better at implementing policies that if they choose to do this, it's something that will be clearly communicated to the students and to the parents to avoid the brouhaha that arises from it being so secretive and so covert. Because as perverse as it may sound and as creepy as it is, and how awful we can wring our hands and say, how on earth could they do this? There is a little bit of an interest here at stake. You got to give the school district a little bit of credit here. There is a little bit of interest at stake in the security of these machines and doing some monitoring for the safety and the security of these machines as assets, and protecting them from being lost and stolen here. So I think that glimmer of an interest here is going to survive and more clearly be implemented from lessons learned in this situation.
Ernie, any thoughts on this?
I agree with Evan, and I think that there is potentially a legitimate interest in recovering stolen laptops, and it's true, and it's important to emphasize that the 6 laptops that these 57 or 56,000 images came from, now it says it counted for most of the images, so it's not necessarily all of them, but most of them were on those 6 reported missing laptops. I think this could have been all prevented, as we've discussed before, if the school district had told the students and the parents that they had this capability. I think that was the big faux pas here.
Well, that seems to be what the school district is hanging its legal position on, that the students would have no reasonable expectation of privacy and that they should not have brought those laptops home, or, I don't know how they would expect a student would not bring a laptop home. That's why you have a laptop, presumably, instead of just using a desktop machine at school. But it seems like, there was probably a pretty muddy communication of what could happen with the devices, and that if that's the case, I really can't see these guys coming out on the right end of this lawsuit, or the winning end. It's a civil case now. Does anybody know if there's anything pending on the criminal side? I haven't really seen any coverage of that, and I just searched Google News for anything related to a prosecution and this Marion School case, and I don't come up with anything. So,
yeah, I don't know either. And there'd be a good argument for qualified immunity here, given that there was this interest at stake of monitoring the assets of the property. It's not like anybody broke into somebody's home and installed a bug or a spy camera or something like that. These people who were doing this were ostensibly working within the scope of their government job. So I would think that there would be difficult to pursue a criminal action on this.
Yeah, you're probably right about that. Okay, so let's talk about something else that we alluded to a minute ago, and that is on Monday the 19th. I'm sorry, is that the date? Monday, whenever that was, this week. The Supreme Court heard the oral argument in the Kwan case. Now, this is the case where there was an officer in the city of Ontario here in Southern California who had his privately issued device through his department that he was using to do SMSs with his both wife and mistress that were of a personal and actually pretty deeply personal nature. And his employer had access to those. And again, we have a Ninth Circuit decision that is now before the United States Supreme Court about whether the employer was authorized to have that access and whether Fourth Amendment reasonable search and seizure protections would apply to protect that information. Obviously, a pretty important case, even though this one involves government employees. I think it would be something that, whenever the Supreme Court speaks on this sort of issue, it will certainly be informative as to private employees as well. And from the coverage I've read, it seems like, well, a couple of things have been the fallout of this case. One is an overall sort of shock and dismay about the Supreme Court's savviness of the technology, ability to understand, what's going on with a pager or SMS and email communications. And the other is that the facts of this case are a little bit muddy. There was the ability to pay extra on your service plan, and one administrator in the department had told employees that if you do that, then we're going to treat your communications as private. And this particular officer had done that, but turns out the guy really didn't have the authorization to give that sort of an assurance. And so we're not quite sure. It seems at any rate like Justice Roberts found that pretty persuasive that, if you paid extra for privacy, then he should have it. So we're just going to have to see what the court does here. Ernie, I saw that you had read one of the articles about the court's tech savviness and then realized that that particular quote was taken out of context. You want to elaborate on that one for us?
Yeah, I think I was reading in my Google Reader the Political Wire blog, which had quoted either the HuffPo or which was quoting some other source, saying that Chief Justice Thomas did not know the difference between paging and email because he asked a question and said, well, what's the difference between paging and email? And that sounded on its face like he didn't know the difference and that would be kind of strange. But I guess some people don't know things that, we in the more tech-savvy world think that they should know. And so I tweeted out about that, and then somebody responded back and said, here's an NPR story about this, and here is the context in which Chief Justice Roberts made that statement. And he was simply posing a hypothetical and then saying, what's the difference between a pager and an email, which, of course, completely changes, the import of what he said and doesn't make him seem like he doesn't know the difference. He's just saying what would be the difference in this hypothetical situation. So at that point, I thought, well, okay, they understand technology a little better than I thought. But then I read more and I realized, well, they're not that far off. They're not really exactly the kind of people you would invite to speak at a Web 2.0 conference because in one of the articles, they was talking about how the text messaging work. And Robert says, I thought, you push a button and it goes right to the other thing. And then Scalia said, you mean it doesn't go right to the other thing? As in, like, they don't understand that, I guess, the concept of a server.
Yes, any sort of intermediary service or network that's making this all happen seems to have been lost on them. Evan, do you have any thoughts or want to make any predictions about how this case is going to come out and the impact that it will have on private employees, if any?
Well, that's precisely what I was going to say. We'll get a holding, and I think it's probably a coin toss as to who's going to win here, whether it's the government's position or the employee's position. But my feeling all along is that the holding is probably only going to be of limited import for the public sector employees here, and at best, what we'll have is an opinion that we'll be able to use by analogy for the private sector. So I'm interested in seeing what the holding is. Looking forward to it. I'll read it when it comes out. Probably blog about it. But I don't think this is going to be a game changer like some other Supreme Court cases that deal with privacy, like the Katz decision from a long time ago, one of the first privacy decisions, or some of the important Fourth Amendment decisions that deal with privacy. It won't rank up there with those, but it will be interesting reading, one that we can use to argue by analogy.
Kevin, do you think that private employees have a lesser degree of privacy by definition because they're at the whim of whatever their employer decides can be done with the information on their devices?
I do. I was actually chief legal counsel for a company with about 50 employees, and I think there's a legitimate interest there to monitor the devices. And Justice Roberts, I think, alluded to this in an oral argument where he said, isn't this stuff buried somewhere in the policies? Usually this stuff is handled in the employment handbook. And arguably, nobody reads that stuff, but most companies are sophisticated enough to have it in there. If you're using email, technically it's on company time, on the company dime. It belongs to the company. And as attorneys, we all know that to be true. When there's discovery requests, we were involved in litigation. We got various discovery requests. We swept in some pretty personal emails, but there was never an issue as far as, hey, you're being too intrusive. Company server, company data. I think the Supreme Court sides in favor of the employer on this case, but I agree with Evan, it might be a limited ruling because the facts are so weird. But it's going to just confirm what we already know intuitively. You got to be careful when you leave a digital fingerprint. Everything you do leaves a digital fingerprint, and if you're using a company device, I don't think you have an expectation of privacy in that kind of circumstance.
Right. There was one telling comment from one of the justices, I think it might have been Justice Roberts again, who seems to have been quite concerned about the privacy of Mr. Kwan, or Officer Kwan. And it was that he didn't want to land us in the ridiculous situation where a public employee would have to carry around two devices to be able to do his or her communicating, one that's strictly for personal use and one that's strictly for job use, that might be, a little bit onerous and burdensome. And yet at the same time, one of the other justices said, okay, so what happens when Officer Kwan is sexting away with his mistress here and there's some crisis that demands his attention as an officer and he has one communication device? Is it, can it multitask, I guess would have been the proper question there, to make sure that, you're not blocking out the legitimate business uses with your personal uses as well, which I think is a good question and a good response to, well, maybe you should have two devices if that's going to be the case. So,
I'd be interested to know how that really plays into the privacy calculus, though. I mean, that doesn't.
Mm-hmm.
I mean, if the issue is reasonable expectation of privacy, I'm sure that we'll see it in the opinion somehow, and or maybe it's in the briefs that have been filed. How the utility of it could factor into this. So that seems a little bit tangential to me, even though it's intriguing.
Well,
yeah, no, but it is something that seemed to get a lot of play during oral argument. There was another comment about, well, they've got to be able to order pizza, and that's not quite a business pursuit. So, it does seem to be at least in the justices' minds.
Well, there's an important part of this case that I carved out and I plan to use, not in the context so much of privacy, but in the case of parking ticket law, because there was a discussion apparently with the Deputy Solicitor General saying that employers have adopted policies telling workers they have no right to privacy when they use computers and cell phones, and that thousands of employers rely on these policies, so no employee can claim a reasonable expectation of privacy if his emails are read later, to which Roberts apparently hopped in and pointed out that oftentimes these policies are like fine print on a parking ticket, quote, it doesn't apply because nobody reads it.
Wow.
I would agree with that.
Valuable in some sort of terms of service dispute as well.
Yeah, and from the Supreme Court. It's very rare that you get the Supreme Court gets involved in parking ticket law, but
yeah. Okay, well, let's talk about terms of service because we have some interesting stuff to get into there. First of all, there was this outfit called a Game Station over there in the UK that did a really, really funny thing. They put a clause in their terms of service that they called the Immortal Soul Clause that basically, it required gave legal ownership of the customer's immortal soul over to the games retailer. And they just stuck it in there. And they also had a little mechanism that if you did notice the clause and click the relevant opt-out box, then you were given a £5 gift voucher by the company. Now, unfortunately, more than 7,500 customers fell for the ploy and missed out on the gift voucher. 12% of the customers did notice the clause and opt out and get the voucher. So that's a good little social exercise in whether people read terms of service and to what extent they're paying attention to them. So thank you, Game Station, for highlighting that for us. And
don't you just love it too that they say the Game Station executives are now assuring all customers that they are not enforcing the Immortal Soul Clause and will contact customers with notice of nullification. That's great.
Yes, thank goodness.
Love this one.
I do love this one. And I love it too in the context of what was going to be our resource of the week this week, which was at first blush, I thought, quite a nifty little iPhone and iPad app called Zosh. And the functionality of this thing is quite nifty. It does allow you to affix a signature that you do with your finger on a touch screen to a document without having to print it out and sign an ink signature and fax it back. It's something that's trying to streamline the process of entering into a legally binding agreement, which is a bit clunky in our day and age. It's all well and good for people to sit and laugh at the Supreme Court for their tech savviness. Well, unfortunately, we're still living in a world where our legal system does lag significantly behind the way business is generally conducted because we do have these mechanisms in place to ensure that people are giving their consent by signing in ink on a piece of paper, usually. So I was going to go ahead and put Zosh in as our resource of the week, but I'm not going to do that now. I do encourage people to check it out, but I also encourage them to check out the fact, as Evan pointed out, that the terms of service for this outfit are pretty darn draconian. And let's see, what exactly did you say, Evan?
Oh, no, I wrote that at 6:15 this morning before I had drank coffee. So if you're going to quote an email like that,
I said, you said, if one of my clients were using this, I'd flip out like a ninja.
Oh, yeah.
You want to tell us exactly when you looked at the terms of service, and if I had a gift voucher for £5 British, I would certainly give it to you for having taken the time. What struck you as bad news here?
The big thing is privacy. I watched the little video, and first of all, I've got to hand it to these folks at Zosh, and the last thing I want to do is get on here and rake them over the coals for anything. I hope this can be kind of a constructive thing that we're doing here, because I'm sure that they're startups, they're doing this on their own money. So I want to say everything good about this. So I watched the little video that they have on the homepage there. Great marketing, great space that they're occupying with all of this stuff. And the first thing that I thought of when I learned that the way this works is, you're on your iPhone and you get a document, a contract that you need to sign. You forward it by email to the Zosh system. So a copy then by necessity resides on the servers. Say this is a non-disclosure agreement with an exhibit, an attachment to it that spells out all the trade secrets that we're going to keep secret. Well, good grief, then a copy of the very thing that is needing to be protected now exists on Zosh's server. We better have a pretty darn good privacy policy here that's going to not only guarantee that they're going to take reasonable efforts to protect the confidentiality of that information, but I need to know how I can get it off of there and how I can control all of this stuff. I mean, the implications are obvious with that. So naturally, we go to Zosh.com and scroll down to the bottom and see the terms of service. And then I scroll through it, and it's difficult to read because it's just a bunch of undifferentiated text. So I then ran a search, searched this page in Chrome, and I looked for the word privacy in there. And so it says our privacy policy. It says see our privacy policy, and there's a web address. It's not a hyperlink, but it's zosh.com/privacy for more information. So I put that in the address bar. I go there, and then it says our privacy policy is included in the terms of service. So this is this recursive thing set up here about the privacy policy, which
I noticed that too.
Which leaves a gap. There ain't no privacy policy at all. And that's, in my mind, the most important thing that's needed in a document like this. So that's first and foremost.
Right.
Yes.
So here's what happens in the application itself. You and I want to talk about this in a little more detail, not just about Zosh. But so you get this little screen where you can create a Zosh account or learn about Zosh. When you do the create a Zosh account, you get the terms of service right here. And then you get that text you were referring to, see zosh.com/privacy. Zosh.com/privacy takes you, and I'll just show people here since I queued it up, to this little page. It says, my iPad will load up here. Oh, it's so small. Let me make it bigger. Currently located in our terms of service, which can be found here. And then when you click here and you go to the terms of service, there is this, as you said, thing that says there's a clause on privacy, and it says go to zosh.com/privacy. So you
get lost in a loop. It reminds me of the and this is an old joke. Right. The guy. It's not even a joke. It's just, I guess it's a story. You walk in, you find the. Oh, this is terrible. Maybe I shouldn't be saying that. It's a skeleton in the shower, and the water is still on. And they say, "What?" Well, you find out that it was a computer programmer, and he's holding the shampoo bottle in his hand, and it says, "What is it? Lather, rinse, repeat." And so, with the computer programmer, he's just going to follow those steps infinitely. You get lost in this feedback loop here, going from the terms of service to where the privacy policy should be, back to the terms of service. So enough.
Here's
Again,
the other hysterical thing is here on this page at the terms of service. Let me get it up there. Is a little widget that lets you tweet the terms of service. No one has done so yet, but I think that perhaps this particular terms of service is one that deserves to be widely tweeted and discussed, and at least brought to Zosh's attention that they need to fix that.
Yeah, again, and I want to say again, I don't want to be raking these folks over, because I love startups. I represent so many startups. These are people behind all of this stuff. So I'm hoping that this can be a good thing that we're talking about it, and not to be mean to them.
Yes,
they can fix it probably in a week. They're slapping their foreheads right now, saying, "How can we miss that?" But there's not much of a business reason for them to keep all the data. So I think they can tighten up the screws and be good to go in a few days.
Right. So, Zash, if you're listening, I think this is a wonderfully cool idea that you have, and I'm more than happy to feature your service as our resource of the week if you fix this bit of a glitch and actually have a privacy policy that makes sense and limitations of liability, et cetera, that are not terribly draconian. And along those lines, I'm going to go ahead and, for our resource of the week, point people toward EchoSign at echosign.com. It's not quite the same functionality, but it is a way of streamlining and e-signing documents that I use all the time. And if you look at their policies, their privacy policy is quite extensive and I think addresses all the concerns that Evan was raising. So there's that for our resource of the week. And also one more thing I wanted to bring to people's attention, which went up today from Gina Trapani over at Fast Company. Time to audit your Facebook privacy settings. Here's how. Nice step-by-step guide through the new personalization features that were just announced that extend the Facebook experience to third-party sites. There are a couple of things called social plugins and instant personalization, and Gina walks you through exactly how to make sure that all of your expectations and desires as far as privacy of your data and what's getting shared with whom are adequately addressed. And I should say that I've had a couple of reports from people that when this was all rolled out, things were made public without people's permission. A Flickr user called The Diesel posted a photo, a screen grab of his or her privacy settings that had their city, hometown, education and work, activities, interests, and things they liked defaulted to everyone without their permission. And also another person on Twitter told me that a similar thing had happened to them. Those are the only reports of that I've seen, and my own privacy settings stayed on the pretty locked down way that I have them configured in Facebook. So who knows, maybe that was a glitch or a bug or something, but there always seems to be something when Facebook updates its settings like this. So go ahead and check out Gina's article. Do check out your Facebook privacy settings to make sure you have not been the victim of any bug, glitch, or other alteration of privacy settings from the way that you want them. And, be careful out there, as they say. So thanks to Gina for always being Johnny on the spot, Jane on the spot, with having great advice and how-tos out there. And so we soldier on. Let's see. So we talked about terms of service. Let's talk about another thing that that happened this week, and that was the Library of Congress, speaking of privacy or perceived privacy, is going to archive the entire universe of tweets that have gone out into the ether since the inception of Twitter. Now, all of this stuff, they're only taking the public ones. So there's not really any sort of privacy ramification there, because presumably if you've made things public on Twitter, you know that they're going out and being indexed in various ways. Now they're just going to be indexed and archived by the Library of Congress, which I think is fascinating. Kevin, any thoughts on this?
Not exactly. You said it when you send out a tweet, you assume that it's available on the internet forever. What I'm curious about is the value. Why does the Library of Congress want to get in this business? How are they going to use the data? I'm not sure.
Well, I think they've been in the business for many, many years of collecting and assembling and organizing our cultural heritage. So doesn't this seem pretty natural thing to do? I mean, what better way to get a very granular, high resolution picture of what society has been like in the last 3 or 4 years than to have, all of these little data points along the way, even if it's as mundane as I'm going to meet Joe at Starbucks right now.
Right.
But isn't that what Google does? Google sort of has a financial interest to create this database of intentions, I think is what Battelle described it as. That's their business to assimilate all this data and create the picture of what we value.
Yeah, there's two ways of looking at this. I mean, I wrote a post about this on April 15th, and I, really at the top of my mind then was kind of how freaky it is that the feds have all of this stuff. But is it any less freaky that Google would have all of this stuff with a profit motive? At least the Library of Congress is, the institution of the founding fathers and all of this stuff. And it's there, and it's for a relatively neutral purpose. Let's hope. And if they wanted to do something, invasive with the data, they could certainly do that. But the more I've thought about it, the less likely it seems that would be the source of data that they would go to mine for information. Instead, the really good stuff for law enforcement would be on the dark web. Underground, hidden off of the public Twitter stream. So I guess I become less concerned as I've thought about it a little bit more.
Ryan Single at Wired wrote about this, and he said, so be careful out there with your tweets and buzzes and status updates. Your great-great-grandchildren will have to do, quote, book, unquote, reports on them someday.
Yeah, and in those days, it's going to be not too hard to filter out the precise things that you want, with the technology, the search technology. Then,
yeah, Kevin, I think you did hit on an interesting little point there. I mean, I don't necessarily see a legal angle to it. Just be aware of what you're doing on the web angle, and that is that Twitter, although I think they've always said that they plan to make tweets available in your own Twitter stream and everybody else's, going back all the way to the inception of when a user opened an account, they haven't in practice been doing that, I think, for logistical reasons more than anything else. When you scroll down and you look for older and older tweets, you get a message usually that says something like, older tweets are not available at this time. So they have been, in some ways, going off the radar a bit. Now, as you said, Google indexes these things as well, and so you have that as a backup and various other search engines. But to have a durable record of them in the Library of Congress is probably not what people have become accustomed to, because obviously it hasn't happened until just now, and it was announced. But I wonder if it will change people's conduct, and I wonder if there's any outrage or sort of privacy snafu associated with any of this. What do you think about that, Kevin?
I think we're sort of in the primordial soup as far as what's going to happen in the future with all this data. We just can't really anticipate what's going to happen. And I'm confused, personally. I just assume that I'm creating a digital legacy that my kids are going to see. And I don't put anything out there that I wouldn't want my son to see or my daughter to see. That's just my personal approach to this stuff. But as far as anticipating the impact of the Library of Congress indexing this stuff or Google indexing it, I don't know if we're smart enough to really anticipate where this is going.
Ernie, where do you think this is going?
Into the archives. I guess it's another one of these things that people have an initial knee-jerk reaction about it. I was at a conference this weekend. There was sort of a gathering of judges and lawyers, and they would meet. It was a small group, and it was kind of a chance for the lawyers to tell the judges things that they needed to talk about, and a chance for the judges to hear. And I was on a panel with another judge, and we did a social networking discussion. One of the questions came up about this whole thing of the Library of Congress, archiving Twitter feeds. And most people immediately knee-jerked to, oh, this is terrible. And then the more they talked about it, they said, well, I guess it's not so bad. That's really what the Library of Congress does, and we're probably okay. But the knee-jerk reaction for pretty much everybody was, oh, this is a bad thing.
I think imagine the biographers of the future having access to this kind of information instead of just having it go off somebody's server and be inaccessible over time. I think that could be incredibly valuable to have a really fine-grained insight into somebody's life on down the way. And, it highlights, too, the fact that people don't usually, especially with these cloud-based services, pay too much attention to keeping a backup for themselves. So if the Library of Congress doesn't step in, then chances are a lot of this stuff would be lost eventually, or, at the whim of whatever service is maintaining the information. The Library of Congress itself on its blog had a few examples of a few important tweets of the past few years, including the first ever tweet from Twitter co-founder Jack Dorsey, which just basically said, let's see, just setting up my Twitter. So nothing too earth-shattering there. President Obama's tweet about winning the 2008 election. We just made history. All of this happened because you gave your time, talent, and passion. All of this happened because of you. Thanks. Now, question whether Obama actually tweeted that or not. But the other,
and he didn't leave much room for retweets.
Yes. Well, that's the funny thing too, is when you pull this up, only 45 people retweeted President Obama's message about winning the election. That just seems terribly sad to me. And then the other things they highlighted were, of course, folks probably remember the story about the photojournalist who was arrested in Egypt and then freed because of a series of tweets, a series of events set into motion by his use of Twitter. And when you check out those, it's actually quite wonderful, because instead of saying, help someone intervene on my behalf, or whatever you could squeeze into 140 characters, the first tweet was simply arrested.
Right.
The second one was free. So
that reminds me. There's a person here. I work at Launchpad. There's a lot of people. It's a co-working space. There's a lot of techies and entrepreneurs. And there's one girl who's very tech savvy, very social networking savvy. And one night I'm getting ready to go to bed, and I look, my Twitter stream, and I see her saying, oh my God, I just got arrested. And apparently she'd failed to pay a parking ticket or something, and she hadn't paid it for long enough. Mm-hmm. And she didn't have Justice Roberts' quote, at her disposal. And so they put her in the squad car, and they were taking her to central lockup. And then she tweets again, I can't believe I'm in the back of a cop car. She says, but the police are incredibly nice. And I was thinking, why not just say, can somebody come bail me out? Or no, just, another little snippet in the Twitter stream.
Yeah. So, circling back to the cultural significance of all this, I sort of think about, now this is a fictional example, but this is what popped into my head. Eliza Bennett tweeting something about that jerk Darcy, and having that in real time to look back on. You're capturing people's in the moment impressions, and I think that can have historical value. So good on Twitter and the Library of Congress for archiving that stuff. And we'll just have to see, a dozen years from now, whether any of that has significance. Let's talk next about Viacom and Google and the latest jockeying in their case. What happened here is more documents have come out in the discovery wars in that case. These ones not looking so good for Google. Evan, did you take a look at these, and what do you think it means for the overall case?
Well, I agree with what they're saying on Ars Technica here about it being kind of a PR thing to release all of these documents. It just seems the nature of the documents seem to just be in the same fashion and pattern as what we were getting indications of, from the summary judgment motions as well. It's no secret that YouTube, Google is in a tough spot here, and these documents just kind of underscore that and add a bit of color to it. So, there's a part of me that really wants to see this case settle as well, just because of the damage that it could do to Section 512 if we actually see some decision on this. So, and that the decision could be on its way. So, I'm concerned about
before we get into the substance of the documents themselves. Elaborate on that. What damage could be done?
Well, there's this whole, that issue is the safe harbor provisions of the DMCA and, how much YouTube knew about infringing content on there. And to the extent that YouTube is not given the protections of the safe harbor under the DMCA in this situation, such a high profile case like this with such big players and such an enormous amount of content at issue, that really is going to undermine the confidence that investors, that people who want to contribute to the infrastructure of the web will have in this notion of how safe they're going to be, how insulated they're going to be from the liability of copyright infringement from content uploaded by their users. Now, there was an interesting piece that was in the links for today, and it was written. I didn't know the guy, but I should have known. He was chair of the International Trade Commission.
Was this the Forbes piece?
Yes,
maybe?
yeah, the Forbes piece. Since it was Forbes, it was much too intellectual for me to be a regular reader of it. So I also didn't know the guy. But a very erudite look at it. But he came out on the other side of this, saying essentially that if we can't have confidence in a reliable DMCA takedown mechanism for content to be taken down at the direction of people who bring it to the provider's attention. Oh, and by the way, the providers are in the best position to identify this content of what's infringing. That was the part where I clearly had to depart from him conceptually. Then there's never going to be any creative incentive to make works, and then the robust nature of the web is going to fail. And that was very much a sentiment that big content has put out for a while, that this is going to eliminate the incentive for there to be new creative materials made and new content put out there to be distributed if it's all just going to be easily pirated. It's just got to be somewhere in between those two extremes of disincentivizing the creation of content and disincentivizing the creation, the investment in internet infrastructure to develop new services and new providers for this stuff. And I just fear that a decision like this, one way or the other, well, actually, I'm clearly more worried about it being harmful to or to undermine or to somehow weaken the protections of the safe harbor, that's going to throw that delicate balance really out of whack and do damage to us all, for those of us who love the idea and the issues arising from the distribution of content over the web.
Right. It's a very intelligent piece in Forbes by Ronald A. Cass, former commissioner and vice chairman of the U.S. International Trade Commission and dean emeritus of Boston University School of Law.
So he's certainly no slouch. He's somebody who would have given these things some thought.
Chairman of the Center for the Rule of Law, who writes and teaches intellectual property and competition law. And yes, he thinks that the impact of this suit will go well beyond Viacom and Google, and that the future of Section 512 is absolving site operators from liability for ignoring rampant piracy would be a recipe for putting the internet under a cloud of creative uncertainty that would chill investment the way clouds of ash from, oh my goodness, I have to try and pronounce this thing, the Iceland volcano.
Why don't you rap it?
I just can't even begin to say how that
Ernie, you do the bass line. Kevin, you can do the
Don't even go there.
The way the volcano's eruption have chilled travel, the effects of a bad decision, however, would not vanish nearly as fast. So that said,
just so interesting how he can come out on use what appears to be a very different analysis to arrive at the same result, namely no more incentive for the internet to work. That's really interesting how there can be very principled and well put together arguments that really just end up on two different sides of the equation, but sound a lot the same all along the way in the steps of the analysis. Just really, really captivating.
Yeah. The documents themselves that have come out and I'm not sure what the process is for how all these things have come out. Is it Viacom themselves who have read through their things they've gotten in discovery and decided, oh, we want to put these out there because they look really damning, rather than just, urging their arguments in the court? I think that's what's happened here.
I think Gizmodo got a hold of them.
Exactly. They were left in a bar.
The old brief in the bar routine.
On a bar stool.
Hate it when that happens.
Viacom could be leaking out these documents just to put public pressure on Google to increase the settlement value. I think Evan's probably right. This case settles. And this is Viacom's way of saying it's going to get worse unless you pay up.
Right. But the point that seems to be attempting to be made here is that they've got a couple of different PowerPoint presentations from the purchase of YouTube by Google, where it's pretty clear that Google is knowledgeable about YouTube's business model and is attempting to compete in the sense of what's Google Video going to do to compete with this juggernaut that is flaunting copyright laws and gaining a huge audience as a result. Or, what are we going to do once we've acquired this site? We don't really have the context for these documents. And I think that Viacom is trying to couch them as, okay, well, this is a conscious business strategy, not for competition on Google's part, but for, looking ahead. They're going to build on that and attempt to bully us into entering into license agreements, et cetera. We'll just have to see what the court thinks about all that. But again, a settlement would be great, but one doesn't seem to be in the offing so far. Ernie, any thoughts on this?
Well, in the grand scheme of things, there's always a few victims, and I guess these wars will take down the Hitler downfall meme, and I think that's really where I get upset.
Yeah, exactly.
Me too. Yeah.
Well, I'm glad you brought that up because it is illustrative of how YouTube's service has changed over the years, and this is something that Viacom urges too. That if Google and YouTube hadn't been so blatantly infringing in the past, then why would they, or encouraging infringement, and heading towards some kind of Grokster-esque liability here, then why on earth would they have changed things and be doing things so properly now, which they seem to admit Google is. And so also in the show notes here is this Hitler downfall meme that has been removed from YouTube in numerous iterations, parodies of a scene from the movie Downfall where Adolf Hitler rants about iPads or content farms or something else in pop culture. And I guess the latest now is he's now ranting about being removed from YouTube. So
that is so meta.
Yes, exactly.
Is it recursive too?
Yeah, I guess it is. A little video about Hitler embedded within a video about Hitler. I guess so.
Yes, exactly. So let's see. We were talking about Grokster just a moment ago. Let's go ahead. Another current event here involving the Supreme Court is the fact that Justice John Paul Stevens has announced his imminent retirement. And he is the author and driving force behind the Betamax decision, which some consider the most important copyright ruling of all time, as Joe Mullen writes over at Corporate Counsel. The Betamax decision, of course, was the first to establish that consumers have a personal fair use right to make copies of copyrighted material for non-commercial use, and allowed for substantial non-infringing uses of a technology to go ahead and legitimize its existence. So we have Justice Stevens departing. First, before I put the cap on that, any comments from our panel here about Justice Stevens' legacy on the court? Evan?
Just it's hard to believe he's been on that darn thing for almost as long as I've been alive. That's all.
Yes,
you know,
exactly.
President Ford appointed him. President Ford was president when I was born. So what an amazing career.
Oh, you youngster. Ernie, any thoughts about Justice Stevens?
We hardly knew you.
He's pushing 90, right?
Yes.
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 And,
if not 90 already. Then
he might be 90 already. It's quite a long-lived... For anybody who isn't aware, Supreme Court justices are appointed for life, and they can stay on just as long as they want to. So Justice Stevens is now finally passing the gavel, as it were. Kevin, any thoughts about this great jurist before he steps down?
You know, I agree with Ernie. I don't know much about him. His name wasn't on very many controversial decisions.
Well, there is this great piece at Corporate Counsel that's in our links about his IP legacy in particular and the Betamax decision and how he was the architect behind it and got the majority together that allowed for that decision to go forward. You know, without that, we wouldn't have home video recorders in any sense, you know, starting back in the video cassette days and going on to the days of TiVo and DVRs, et cetera. So, thank you, Justice Stevens, for that legacy. And
he just had his 90th birthday last week, and I guess I should also mention I'm just proud of him from being from Chicago, you know, University of Chicago, and for undergrad and Northwestern for his law degree. So a non-Ivy League. I think he's the only non-Ivy League jurist on the court right now, isn't he?
I don't know that.
Come on, why did I ask that? Like
off
you
the
guys
top
all
of
have
my
it.
Head.
Yeah, like you all have it memorized. The reason I said that because there was
their
that
pedigrees at my fingertips.
there was the thing in the notes that you had about that guy out there from the Ninth Circuit from Montana who is on the short list. And I think something in that said that there were only like 8 of the 9 people on the court now were Ivy Leaguers. And so I just now saw, because this was a total Wikipedia moment when we were asking about how old he is. And so I look over here and it reminded me that he's from Northwestern. Stevens is. So that's where I get that.
So the capper to this is there is one of his shortlisted potential replacements is Judge Sidney Thomas on the Ninth Circuit, who himself authored the Grokster opinion that was overturned by the United States Supreme Court. So this was the decision that decided that Grokster was not liable for the infringing activities of its users and that it hadn't induced infringement and all of the things that the Supreme Court went forward and found and ultimately reversed him on. So it would be interesting to have him replace Justice Stevens on the court if, in fact, he does so. So apparently he's in the running for that spot. And it would be, who knows, you know, we laugh on this show a lot about the Ninth Circuit getting reversed by the Supreme Court. It would be interesting to have a former representative of that court finally sitting on the high court and see if it makes a difference.
And just to be clear, we're laughing with you. We're not laughing at you.
Yes,
Sorry.
exactly. So any other thoughts about Sidney Thomas, Judge Thomas? Ernie?
Yeah, I mean, I found that interesting. I also found he seems like a reasonable fellow, and I would love to see somebody not from the cookie cutter formula that we seem to use to pick Supreme Court justices. And I think it would be great. I noticed in the little blurb that he apparently had taught Arlo Guthrie, and I didn't know that Arlo Guthrie ever went to law school. And I realized the article says he attended the school but never graduated. So maybe he just kind of learned how to sub and cite and to shepherdize cases and then bailed. But yeah, folk singer Arlo Guthrie, he was one of his students.
And there we go. That's bound to give you a good background as a Supreme Court justice. Yeah. Any association with Arlo Guthrie.
I think I read somewhere he's a guru in First Amendment issues. which I think is pretty important. I think with the ubiquitous, whatever word I'm looking for, with the far-reaching expanse of the internet.
Everywhere.
Yeah, it's everywhere, and so we're moving. We're really flirting with kind of redefining First Amendment issues, and so you want a guy that's well versed in that space to handle these cases. I think a lot of cases are going to be coming to the Supreme Court as far as the limits of First Amendment protection with anonymous speech on the internet. You know, if you leave an anonymous comment on a blog, you know, how much protection do you get? I don't know. I think there's going to be a lot of First Amendment cases, and he seems to be a guru in that space. I also like that he is pro little guy. He's very pro consumer, which for me in my industry, that's pretty important. So, you know, just at first blush, for what little I know about this guy, I like him.
So if he gets on the court, we're all going to be file sharers and Amway salespeople.
You got it. That's right.
I'm just going to be a file share. I don't think I'm going to be an Amway salesman.
Oh man.
No reason not to try both, Ernie.
Nah, you know, everyone's got to have principles.
Well, we'll get into that a little later, hopefully. But first, since we're on file sharing, I want to hit on our tip of the week, and that is if you should get a warning that looks like this. Hold that up for you. Warning, privacy detected. We see that you have been torrenting files. Please pay us $400 and we'll immunize you or whatever from all of your nefarious activities. That is a scam. This is a bit of malware that is targeted at BitTorrent downloaders, trying to entice them. I guess what it does is insinuates itself into their system and does an actual search it displays files as evidence of earlier infringement and then attempts to scare people into paying them money, which is a fascinating bit of social engineering for a bit of malware. I think, you know, generally they're just trying to take over your computer, not actually extort you. So look out for that one as our tip of the week. And a couple of related links. Let's see here. One was, just a couple of statistics I thought it interesting to toss out and have you guys spin your thoughts out on. One is that a report from Google says that 15% scareware accounts for 15% of all malware. Scareware being something like this that tells you that there's, you know, something wrong that you need to address. The ones that I see all the time, well, I actually don't see them because I use a Mac and I think I'm pretty much immunized from this stuff. But from time to time on other people's machines, I see these things that say that my system has been compromised and I must immediately click here to run free antivirus checking. And what this notoriously does is install malware on your system. Let's see. The report from Google says that fake antivirus currently accounts for 15% of all malware Google detects. It accounts for 60% of the malware discovered on domains that include trending keywords and is 50% of all malware delivered via ads. And it was based on a 240 million page sample. So I thought that was kind of interesting. And then the other sort of hand in hand with that, another statistic is that 1 in 6 teenagers say that they hack. 16% of 1,000 teenagers admitted to some kind of hacking, which apparently in this study included accessing somebody's Facebook account or email. So, Evan, let's start with you. What do you think about all of these nefarious activities and our youth?
I'm surprised that this so-called scareware is not responsible for a larger percentage of malware. And I base that on the conclusion that it has to be tremendously effective because it preys on the lack of sophistication of the user, especially in an environment where the user is going to be upgrading their operating system and may not be accustomed to the ordinary interface of either the application or the operating system itself. Because using a computer, if you think about it, and I'm just being very essential here, we all do it as second nature. But to many users out there, it's still a very sophisticated. Well, to all of us, it's a sophisticated undertaking. But to a large fraction of the users out there, it's still challenging knowing how to turn the darn thing on. So that the use of this scareware, putting up a message that looks legitimate and invokes or induces an action on the part of the user, just seems like it would be enormously effective. So I'm surprised that given the potential for great payouts, like what we talked about with that with the example you gave, moving away from little micro payments to the hackers, moving into large sums of money. Send us $300 or $400. It just seems like those two things working hand in hand would be this a pretty lucrative enterprise. As far as the teens doing this, I'm not sure that should come as much of a surprise to us. Sounds like the definition of hacking in that article was pretty broad, and it could include just figuring out people's passwords, guessing, a little bit of quite a bit of human involvement, and not all circumvention of technologies and decryption and things like that. But people of all ages enjoy mischief, especially the younger set. So that doesn't come as a surprise to me. Also, given the reputation that that generation has for very much exhibiting how they are digital natives. So
right,
good,
it was
good
Dan Chev over at ZDNet who had both those posts on these security statistics, and he, in culling through the data, notes that a resourceful 7% of U.S. kids thought they could generate an income from their hacking activities, with 6% viewing it as a viable career path. So going along with the ransomware folks and targeted at the BitTorrenters, apparently this is particularly in a down economy, one presumes. Folks would be looking to whatever kind of quick buck they can turn through their web savviness for perhaps being their future security. Ernie, does this frighten you at all? And how do you think, as a society, we need to respond to this?
It doesn't frighten me personally. In terms of the implications, I don't know. I mean, it reminds me of sort of a scam. It reminds me of the movie, the David Mamet movie, House of Games, where the con artists play on people's sense that they're doing something wrong, and then they want to buy their way out of it. So it's sort of a play on that. And somebody in the chat room called this, by the way, ransomware, which I think is a great name. So it's obviously designed to take advantage of the guilt feelings, if any, people have guilt feelings that are using these sites to download music and whatnot illegally. I doubt that a lot of people just send the money, but maybe they just have to tweak their social engineering algorithm a little bit, and then they'll be profitable.
Right. I mean, presumably, if you're collecting money from someone, there's a trail that's being left there that could be tracked, and you could be shut down. So I think you'd have to be pretty creative in your money collection efforts. I mean, unless they're terribly sophisticated about it.
This could be a branch of the Nigerian email scammers. That this could be a sort of the elite unit developing some new prototypes.
The SWAT team.
Yeah.
Kevin, any thoughts on hacking?
I wrote it down when Evan said it. People of all ages enjoy mischief, and you're always going to have this. When I was a kid, I stole notes from people. I under this definition of hacker, I would have been considered a hacker. I think what's going to happen.
Good thing the statute of limitations is run.
That's right. Yeah, it's long past 5 years. I I think what we're going to see is we're going to see technology get better to protect average people. Right now, we might be a step behind, but with Windows 7, it's supposed to be a little bit better. Google Chrome is pretty good at catching phishing scams and malware. So maybe technology will ramp it up a little bit to protect people. But maybe I'm being naive. Maybe the hackers are sophisticated enough they can always stay one step ahead of the game. But in this era of transparency and openness, we've got to figure out how to deal with this stuff. It's not going away. People are imperfect and we do stupid things.
Absolutely.
My deep thought for the day.
Every day. Otherwise, we would all be unemployed.
That's right.
Okay, so Kevin, I'm going to have you chat about the, Word of Mouth Marketing Association and what happened with them this week. Have you followed this or taken a look at it in the show notes?
No, I haven't. Give me the summary.
All right. So Seth Godin, who is someone that you've referred to already in the show, and you're a fan, correct?
Big fan. Yeah, I think the guy's he's the Yoda of marketing.
Right. So
the Yoda of marketing, he is.
That's right.
Of marketing, the Yoda he is.
Great.
We can do this all day.
Yes. He has
all day this we could do.
He has a great post called Cannibalism and Spam, where he has pointed out that the Word of Mouth Marketing Association, I guess, did some robocalls to its members. They got called to the mat on Twitter. I want to personally thank you for robocalling me 10 times in 3 minutes during an important meeting, that sort of thing. And their response was, looks like we stirred the pot with our robocall today. In case you missed it, here it is. Let's keep the conversation rolling. And Seth Godin thought that this was really, really bad. It sounds really, really bad to me. And was, basically an instance of this Word of Mouth Marketing Association spamming thousands of people by phone and then not really sort of apologizing for it, but attempting to just keep it going in some way and keep the marketing effect of it going. And Godin's point was that, let's see, he says it in here somewhere. In case you missed the first part of our show, the future of marketing is based on permission. It's based on sending messages to people who want to get them, who choose to get them, who would miss you if you didn't send to them. And this all kind of plays in with what we were talking about with Facebook's privacy settings earlier, because the whole point of Facebook trying to make things more public is to facilitate marketing relationships between its members and people who will come along and pay for access to those members. So, Kevin, you're in a unique practice niche where you service people in the multi-level marketing industry, and I'm wondering if you have any thoughts about the future of marketing and what Seth had to say here about this spam instance.
Well, I agree with 95% of what Seth writes. And in this case, he's right. The Word of Mouth Association, I've never heard of this group, and they're not affiliated with my industry, with direct sales. Mm-hmm. And their method seems inconsistent with their name. It's word of mouth, it's relationship marketing, and here they are spamming people. So there's a disconnect there that I'm not quite understanding. The niche that I'm in is I help startup companies that they have a unique product. It's not going to be carried in Walmart or Target. They want to have a sales force that can sell the product and recruit people to sell the product, and they don't want to be a pyramid scheme. I take care of those people, and I also sue pyramid schemes. I sue the bad guys. I represent the good guys. And it's obviously word of mouth marketing. It's always been around, but now we can make money doing it. We've always told people about restaurants. We've always told people about the movies to go see. Well, now with affiliate marketing and direct sales is sort of on an upward tick right now. People can actually make money talking about various brands. With all things, though, there's room for abuse. You've got the scammers out there. They mislead people. They abuse people. They make gross income claims. You can make millions of dollars if you just click this link and forward it to all your friends. A lot of times it's not true. So, with all things, there's good and bad. But Seth's main mantra of permission marketing is absolutely on the spot, right on the money, and I buy into it.
Yeah, as do I. Can you explain for us, because I'm curious, how you can have a multi-level marketing-oriented business and have it not be a pyramid scheme?
Yeah, well, there's sort of a perception of the industry where if it's a direct sales company, it's perceived to be a pyramid scheme, and largely because a lot of these companies try to fly under the cloak of a legitimate direct sales company, but they're really pyramid schemes. How you can tell the difference is if the product is actually marketable. If a sales force is selling $100 fruit juice, and the only way to make money is to recruit more people to buy fruit juice for themselves, you're recruiting participants in the program. You're not making sales to actual customers, people outside the program.
Right.
Then what you're doing is you're relying on your compensation plan. People are buying the item mainly because they want to participate in the money transfer scheme. The item is a token product designed to conceal the money transfer. So the key issue is marketability. Is the product marketable, and are non-participants buying it? If not, it's just a recruitment scam, and it's a pyramid scheme. And unfortunately, most people, when they get pitched to join a business as a distributor. They don't get sold a product. And that's where we can do better as an industry. And actually, I've proposed some legislation in Tennessee recently, and a lobbyist group came in town and basically shut it down. The Republicans initially thought, oh, yeah, this is a good idea. You want to sell marketable stuff. All of a sudden, a lobbyist come in, and keep in mind, this is an association that's had 10 member companies shut down as pyramid schemes. 10. They come in and say, well, it's overly broad. And the Republicans say, this is maybe we shouldn't pass this legislation. So it's frustrating, and we're trying to fix it up, clean up the industry.
I have a couple of questions. Is your industry impacted by the FCC's disclosure guidelines?
Yes.
That went into, so describe that for us, and without disclosing client confidences or product information. What do you tell your clients about that?
Just disclosure. There was sort of a knee-jerk reaction against the FTC's amended guidelines. I tend to agree with it. The issue is, if in my industry, if you are a distributor and you're talking about a product, you just need to disclose the fact that you are paid by the company. So there's really not much of a negative impact in the direct sales industry. Just companies need to be more sophisticated and educate their people. Look, when you make product claims, when you say this stuff reduces inflammation in your joints, or when you say this stuff led to weight loss, you need to disclose the fact that you are a distributor. Pretty common sense stuff. So the impact isn't that substantial, in my opinion.
Right. And then, so it sounds like, because your website is for the MLM attorney, the multi-level marketing attorney. And when I think multi-level marketing, I think recruitment. I think, we're trying to get other people selling this product along with us, and then we profit from their profits to some extent. Is that an inaccurate concept?
It's true. Absolutely. Okay. It's true. And recruitment is an important function for a direct sales company. You want to recruit a sales force, but at the same time, if you have to recruit constantly, and the people you recruit have to recruit constantly, that's an unsustainable model, right? Mm-hmm. We all know that to be intuitive. Bernie Madoff was a scumbag because it was destined to fail the moment he started. And so in direct sales, how you prevent that mathematical consequence is you require your distributors to make external sales. So, okay, you can recruit, but if you want to make money from that downline volume, the volume of your recruits, you have to make sales. You have to demonstrate proficiency in selling. That's the whole point of direct sales. You are directly selling to a consumer, and a lot of times that gets brushed under the carpet because it's easier for a sales leader to create this charismatic environment where they say, just buy $300 a month worth of jungle juice and it'll change your life, and get 100 people to do the same. That's an easy message, as opposed to actually selling a $100 bottle of jungle juice to a customer, because clearly a customer doesn't have that incentive to make money. They're buying it for the value. So a lot of companies rely primarily on recruitment, and it's not proper.
Right. And are your clients, are you encouraging your clients, and how do you think this is going, buying into this whole concept of permission marketing, where you're marketing people who would miss you if they didn't get the emails that you're pumping out?
Yeah, absolutely. And sometimes it's an uphill battle, and sometimes people get it. A lot of times, this industry is just notorious for spam. I had a Skidoo page. That should tell you how big of a Seth Godin fan I am. He's the guy behind Skidoo. I had a Skidoo page, and I had 2 references to network marketing and just promoting my practice. And they deleted the page just because it had those words on it. And they says, well, we have a history of spam, and you're out of here. And so because a lot of these companies, a lot of these distributors, they're just looking to recruit as many people as possible. There's a lot of people go bonkers, and they just send mass emailers, and they just hit Facebook, and they go crazy. And it drives Facebook crazy. I've actually had conversations with Facebook's compliance attorney out of Seattle. He doesn't like the industry. And to an extent, I sort of agree with him, because they leverage the Facebook platform and they just create a mess. So I'm trying to advise clients to have a clean image, grow organically, create incentives that lead to good behavior. Everything is driven by the money. And if there's money in recruitment, they're going to recruit and they're going to go crazy. If the money is in making external sales, well, that's what they'll do. And so that's sort of the advice that I give.
Well, that sounds pretty smart. Evan, do you have any thoughts on permission marketing and spam and violations of things like Facebook's terms of service and how people are approached?
Well, that's. I mean, I certainly can't add anything to what Kevin said about it, because he spends so much time thinking about these issues, and he obviously is the expert on this stuff and has built the reputation for himself very well on the web about these things. My comments would go back toward this word of mouth marketing association, these shenanigans that got us on this topic in the first place. And it really just seems like with this RoboCop situation and the fact that they violated this edict.
Robocall?
Yeah.
I don't think RoboCop showed up at anybody's door, although that would have been fun.
Right, and hearing them on the other line, man, imagine that.
Yes.
It really does seem that activity is just so toxic that it's lose-lose for somebody who's going to do that. Because with Seth Godin putting down the efforts that that Womma, I guess you would say it like that, made to save face, namely, let's keep the conversation going. I mean, isn't that what you're supposed to do when you kind of mess up in the sensibilities of the way the world is these days? I mean, we've talked a number of times about the Nixon Peabody scandal a couple of years, 2 or 3 years ago, when they, this thing got out. They messed up, is the way we can generalize it. They messed up using social media. They messed up. Social media caused them to mess up. And what they did, they threatened litigation. They did all this stuff. We can think of a number of other examples. Well, Womma could have the Word of Mouth Marketing Association. I don't feel comfortable calling it Womma. I just don't know if that's what it looks like, right? They could have.
Who's your Womma?
They could have gotten all righteous and said, you called us spammers, we're going to sue you for defamation. We don't, we're anything but spammers. They could have, made all kinds of arguments and been real hostile about this. And that would, of course, been lose, fail. As what Merlin Mann would say, fail. But here, what they did is the best way, I thought, of saving face, but yet they're still getting called out for it. So maybe it's just one of those things. Robo-calling is just so toxic that you can never not lose when you engage in those practices. That's what my thoughts are on this.
Yeah, I would tend to agree with that. I would have liked to see an apology from these guys, if they're trying to be googly or transparent or responsive or whatever you want to call it, rather than just gee, looks like we really stuck our foot in it. Well, actually, they didn't even say that. They said, it looks like we stirred the pot. In other words, people are talking about all this. Well, yeah, they are, and they're ticked at you. Ernie, any thoughts?
No, it just sounds like the Word of Mouth Marketing Association had that problem that is described in a famous song by Mose Allison. Your mind is on vacation, but your mouth is working overtime.
Yes, indeed. Okay, well, I wanted to actually, we're getting down toward when I'm going to wrap the show, but there was something I wanted to circle back to. So I meant to bring it up when we were talking about terms of service and reading them or not reading them. And one thing that I haven't heard anybody discuss yet, and I wanted to just quickly get the panel's take on this, is how that plays out in the ecosystem, in the app ecosystem that is so rapidly evolving on devices like the Android phone platform and the iPhone platform, where you now are not interacting with a website or encouraged to click through a terms of a document entitled terms of service or whatever. You're simply downloading an app, and oftentimes you're paying for them. And, maybe there's a terms of service associated with it, or maybe not. It seems to me like these applications are out in front of the legalities that may apply to them at this point. The Zosh application that we looked at before, at least, but as you were going through the account process, they were trying to get you to buy into their terms of service before you went further. That is one of the first iPad or iPhone applications I've seen that's done that. Most of them, and for example, here on my iPad, I have Yoga Stretch, which has this nice little yoga routine you can go through. And all you do, here it is, you tap the screen and it starts. Begin is the big button. And, it starts doing its thing for 59 minutes of yoga. Now, when I go to take a yoga class, they make me sign all kinds of waivers and things before I can jump in and have the enlightenment their instructors offer. And I think it's just a symptom that perhaps the app development is happening in such a kind of quick and dirty, streamlined atmosphere, and that's probably part of why it's working well and catching on and not encumbered by a whole lot of legalese. But at the same time, I think you're getting yourself into relationships with sites that either may not be governed by specific legal terms, or perhaps you're even less likely to read somebody's terms of service that might apply in that kind of context. Ernie, any thoughts on that one?
Well, I guess the practical side of me wants to acknowledge what Justice Roberts said, which is that, even when you're presented with terms of service and you have to click things, very few people read them. I'm one of those very few people. I kind of feel like, well, if I want this application or I want this piece of software, I'll just say yes. And I wonder, I wonder how that's going to play out, because we're building all this on an assumption that people really do read these things. Now, now the assumption is either it doesn't matter whether they read them because they've signed them and aha, I've got you, which is kind of almost like the ransomware approach to getting stuff signed and people to agree to it. Or we're going to have to say, well, here are the kind of things that you can make people agree to, or that they agree to by default, because they're using your service, and here's how far we can take this. And I wouldn't be surprised if somewhere down the road that's where we get to, because I don't think we've really seen a lot of litigation about these terms of service and whether they're valid, cutting to the core of it. We presume they're all valid, but hey, if the Supreme Court justice is going to say in one context, hey, it's like a parking ticket, nobody ever really reads these things, in reference to employment policies, which are presented with much more, moment of seriousness than these sorts of things that pop up on our computer screens. I just think we kind of need to reevaluate it, and we probably will down the road if anybody really presses the issue and it becomes a big deal in court, and if it makes its way all the way up to the Supreme Court, and if Chief Justice Roberts is still on the court. How about that?
Right.
We've got quite a bit of useful law in this space, and I'm comfortable with the state of the law as it is now. As to the mechanics of online agreements, click wrap agreements or whatever, I think that we have a pretty good legal framework to operate in here. So what we need to focus on, I think, in making this discussion most meaningful is the factual inquiry, the way that the relation between the person downloading the application is vis-a-vis the provider of that application. And the leading case on this, or the one that you see at least cited quite a bit in the enforceability of online contracts, is from the Second Circuit from 2002. It's called Specht versus Netscape. And in that case discusses this notion of a reasonably prudent offeree of downloadable software. And that's really what we have here. What is an ordinary person going to think in this kind of context when they're downloading an app? What's their understanding? And there really are two things that the court in that case requires: a reasonably conspicuous notice as to what those terms are, or that they exist and what they are, and then also an unambiguous indication or manifestation of assent of those things. So to the extent that you can download an app and you're not made aware of those things, like for example, I think this would run afoul of the Specht reasoning here. If you're going to be able to download that application and never have the opportunity to even know that there are terms that govern this, that's tenuous and runs the risk of peril if the developer actually wants to impart some important terms on the user. So
right. So my question to you before you said all that was whether you thought that browse wrap agreements were going to perhaps gain more effect through this process. And it sounds like under the Specht decision, there is some safeguard against that. Am I hearing you right?
Can you define browse wrap? I've never heard of that.
Browse wrap is one of those where you don't necessarily have to actually click on an I accept button, but it's your assent to the terms is imputed because you have, well, it's not necessarily imputed. I mean, you do accept because of your visiting the site. A great example, there was a case from Missouri not too long ago where, that throughout the checkout process, or the registration process for I haven't thought about this case in a while, so it's just bringing it back up to consciousness and spouting it out here. There was a little link to the terms of service that had a forum selection clause that was visible to you at each stage along the way, but you didn't have to actually read it in order to be to complete the registration process, or you certainly didn't have to click on anything that say I agree. And the court found, I think it was in Missouri. I don't know if it was the district court there or the state appellate court, but the court found that was enforceable, and the forum selection clause that required the action to be litigated in the city and county of Denver, Colorado, was enforceable and bound the plaintiff, even though she admitted there was evidence in the record that she never actually clicked on that and never actually read those terms. So it's decisions like that, which are of more recent vintage than the Specht case in 2002. It's decisions like this Missouri case which would lead me to think that the notion of a browse wrap agreement is more likely to be enforced looking at the notions of common sense in a factual approach, not a legal approach, but a very focused factual evaluation of this, defining what it means given the technology, given the mobility, given the way that these applications are developed. What does it mean factually to fit into this legal notion of the reasonably prudent offeree of downloadable software?
Right. Jay in the chat room has put his finger on one aspect of why I thought the whole for pay aspect of these applications versus a free website was relevant. And what he's pointed out is that, so you've paid for an app and you download it and it's on your device and you're ready to use it, and it compels you, Zosh being one example, to go ahead and consent to its terms of service before you can use the app. Now, Zosh actually is free, so that's not a good example. But one that you've paid for, say, that compels you to assent before you can use it. I think that's an interesting little twist, because and what Jay in the chat room is saying, it's coercion. You're under duress because you've gone ahead and paid, and you're not going to get your money back if you say, no, I'm not going to agree to these terms of service. So they kind of have you. If you want to use the app, you have to agree. So and there are all kinds of arguments about why these agreements are one-sided and contracts of adhesion, as the legal term goes, to begin with. And this just, I think, adds another layer to it. If you're poised, ready to use the app, and they go, you've got to agree to our terms first, even though we've taken your $9.99 or whatever you may have paid. You're going to be under further impetus to go ahead and say, yeah, whatever this says. Okay. Do you think
it all, you raise a good point. I think it all hinges on the terms of the agreement. Mm-hmm. And Zosh isn't free, actually. I paid $3 to get it a couple hours ago.
Oh,
yeah.
Okay.
So
it
falls in that category, and you're right. You pay the money, and then you just click accept. And I did read the terms because of Evan's email. He mentioned some of the terms in the terms of service, but usually I don't. But this happens a lot in my industry because a lot of new participants, for example, they enroll online. They'll click a box saying they've read the policies. Policies in this industry are over 30 pages. And a lot of times they agree to arbitration clauses, and they agree to restrictive covenants, a non-compete, non-solicitation, trade secret. I mean, really, really brutal contractual provisions that people agreed to, but they don't understand. And when the contract is too far-reaching, the court strikes it down. So I think in this context with apps and websites, it just depends on how far the developer or the website owner wants to go with its agreement. It really depends. If there's a restrictive covenant in there, they've got to make dang sure that they give the reader every single opportunity to read that provision.
Mm-hmm. Ernie, do you think that this is going to bog down the apposphere as people try and make sure that terms of service have been adequately consented to?
No, I don't think so. I think the apposphere is bogged down enough with, getting apps approved. And I think that that's actually getting better. And I think that apps are small little things. I don't think the apposphere is going to, be in peril because of this. But I don't know. What do I know? I'm just a lawyer.
All right. Well, this just in from the chat room. Thank you, whoever shot this our way, that there is a police probe pending. This is up at CBS News on the lost iPhone purchased by Gawker Media. Let's see. Apple has spoken to local police about the incident, and the investigation is believed to be headed by a computer crime task force led by the Santa Clara County District Attorney's Office. Apple's Cupertino headquarters, blah, blah, blah. Okay, so apparently, although Apple has not come out yet with any particular civil claims of its own, apparently it has sicked the DA on Gawker Media. So we'll see what happens with that. Thank you, chat room, for always keeping us up to speed. And with that, I think I'll go around and see if anybody has any last thoughts before we wrap the show. Ernie?
Just that if anybody has HBO and they want to watch the HBO series Treme, it's actually a very authentic depiction of New Orleans, unlike those cheesy things like The Big Easy that Dennis Quaid and Ellen Barkin were in.
That thing was terrible, wasn't it? Tell us about Treme. What's it like?
It's great. Well, it's David Simon who did The Wire, and the first two shows have aired. The first one was a pilot, so that one they weren't sure whether they were going to continue when they filmed that, but then they were approved for 1 year, and they've been approved for another year. And it's basically set in New Orleans 3 months after Katrina. And it's if you've been to New Orleans as a tourist, you won't necessarily know all of these places that they're talking about. And that's what I mean when I say it's very authentic. It's about the places that people in New Orleans tend to go, and not so much about Bourbon Street, which is, of course, where the tourists immediately head.
Cool. Well, we'll look for your cameo.
Okay. Hopefully Thanks. I'll be in.
Kevin, any last thoughts before we wrap?
No, I've just had a great time. I appreciate the invitation, and Evan and Ernie, it was a pleasure to hear you guys speak. This is a bright group you've got. I did my best to keep up. I hope I can do it again someday.
Hey,
Sure.
well, you added a lot. It was nice. It was fun.
Yeah, absolutely. Same. I totally agree.
And I'll make that 3. Evan, any final bits of wisdom?
If there is an arrest or a civil complaint filed between now and 2 weeks from today concerning the, we'll just call it the, that iPhone, I will wear a New Orleans Saints jersey on the show.
Wow.
You heard it here.
Well, I'm not going to say that you're wrong, because I'm not going to start shopping for your jersey just yet. But if you move the timeline out a little bit, I will.
Well, okay. 3 weeks. I'll give you 3.
Okay.
All right, we're going to hold you to that. The folks, you've been listening to This Week in Law with guests Evan Brown from InternetCases.com, at InternetCases on Twitter. Evan, always a pleasure, and we'll stay tuned to that and see what your wardrobe's going to look like in 3 weeks.
Terrific. Thanks for having me.
My pleasure. Also with us, first-timer, but did a wonderful job, Kevin Thompson. Kevin is Kevin_Thompson with a P on Twitter, and you can find him at theadvocate.group.net online. Kevin, it's been a pleasure.
Likewise. Appreciate the invitation.
And Ernie, enjoy Jazz Fest. Enjoy your HBO series. And
I will.
Folks can find Ernie at ernietheattorney.net, and he is Ernie Attorney on Twitter. Go follow his endlessly archived Library of Congress accessible tweets.
And don't go to Jazz Fest right now, because now it is raining.
Oh, dear Lord. Well, okay. So the chat room said before when we launched the show that I had doomed the city to torrents of rain.
No, it wasn't your fault.
All right, good. And I'm Denise Howell, and you can find me online at bagandbaggage.com. I'm over on Twitter at dhowell, where during the week you'll see lots of links related to our forthcoming shows, usually tagged with the hashtag #TWiL episode number, so you know what we're going to talk about when. And this has been a really fun show. I'm glad to have been here with you guys. Thanks a lot.
Okay, take care.
Take care.
See you around.
Bye, all.